My name's Hannah. I'm a Board of Immigration Appeals accredited representative, and I do almost exclusively U-Visa cases. Thank you all for being here and for your interest in taking a U-Visa case with our office. It's really, really important because it's one of our one of the areas where we have the highest demand that we're unable to meet. Has anybody done an immigration case before, or is anybody an immigration attorney?
No, I've done a case.
You've done a case, okay. Has anybody done a U-Visa case before? Yeah, okay. So some of this might be review for you, but and so what we're going to do first is just kind of go through the eligibility requirements and the benefits, and then we'll get into more detail about the process of filing a case. But feel free to jump in with questions at any point. Okay? Okay. So this is where the law comes from for U-Visa. It was created by the Victims of Trafficking and Violence Prevention Act in October 2000. And we have the statutes here in case you want to go and look at them directly. And then for memoranda, also you can go to the website for U.S. Citizenship and Immigration Services, or ASISTA online is another good one. So the purposes of a U-Visa, they're basically, the first one is to assist law enforcement in creating trust with immigrant communities and immigrant victims. There, especially in immigrant communities, there's a lot of fear of law enforcement, and that can come from basically two things. Ideas that people have of law enforcement and who they will help and won't help based on their experience in their home country. And then in addition to that, their fear that having any sort of contact with the police will lead to them being deported. And so it's really to encourage immigrant victims to report crime and to assist with the investigation and prosecution of the crime in an attempt to make communities safer. And then the other purpose is a humanitarian purpose for the victims. A lot of people who have been a victim of crime are need to stay here in order to have access to services and protection that protection of law enforcement here in the United States, and services such as counseling services, medical services in a lot of cases that they wouldn't be able to access in their home country if they were deported. So the benefits of a U-Visa, it's a temporary legal status that's valid for 4 years that comes with work authorization. And people who receive U status also have the opportunity to apply for certain family members, and I'll get more into that in detail in a little bit. And then after 3 years in the United States in U status, they have the opportunity to apply for permanent residency. And so one thing that's important to stress with your clients is that they their status, once they get U status, is going to expire in 4 years, and they are the ones who are responsible for seeking services in 3 years to begin the process of applying for residency. And so that's something that we try to stress with our clients, is that they won't receive any notification from immigration or from us or from anyone to tell them, oh, it's time to apply for permanent residency. So that's something that needs to be communicated to them. That's really important, that if they don't apply for residency in that year after they are eligible before their visa expires, they essentially lose the opportunity. Their visa expires, it can't be renewed, and they lose the opportunity to apply for permanent residency, with a few exceptions, but in general that's the case. So I'm going to talk about principal applicants first, which would be the main crime victim, and then I'll talk more about their family members that can be included. So these are basically the requirements for someone to be eligible for a U-Visa. They have to have been a victim of a designated crime in the U.S. I'm going to go into each one of these in more detail. They have to have suffered substantial physical or mental abuse as a result of the crime. They have to be helpful in the investigation or prosecution, and that can include if they've been helpful or they're likely to be helpful in the future. And then they also have to be admissible to the United States. So this is the list of the designated crimes. So someone has to be a victim of one of these crimes in order to be eligible for a U visa, or any similar activity or attempt to commit any of these crimes. And because, oh yeah.
The first one you have on the list is domestic violence.
Mm-hmm.
So what factors do you consider when there's been domestic violence, whether to file the applicant under U visa versus VAWA?
Okay, so the main determining factors between U visa and VAWA is that for VAWA, it's the person has to be married to someone who's either a U.S. citizen or a permanent resident. And so there are two components. The relationship is important. It has to be a legal marriage, which in Texas includes common law marriage. And the status, the immigration status of the abuser is important. So they have to be either a permanent resident or a U.S. citizen. With U visas, the relationship between the victim and the perpetrator is irrelevant. And the status, the immigration status of the perpetrator is also irrelevant. So, in general, I would say there are a lot of people who could qualify for a U visa based on domestic violence who wouldn't be able to qualify under VAWA because it's more restricted.
But let's take the hypothetical where we have a case that could qualify under either,
Under both.
which wouldn't be infrequent.
Right.
Strategically, in thinking about the best avenue for the applicant, which course would you want to go?
It depends on whether the applicant was married to a citizen or a permanent resident. Because if they are married to a citizen, then they can do what's called a VAWA 1 step, where they do the petition to prove their relationship to the U.S. citizen and their application for permanent residency all at once. And so it's basically a faster route to permanent residency. If they are if they are married to a permanent resident, they would first need to have the petition approved, and once the petition is approved, they're eligible to apply for a work permit, which they can renew each year, but they're given a priority date that depends on where they're from, and that priority date determines when they can actually submit the application for permanent residency. So in some cases it would be, and basically what we want the faster avenue to permanent residency because it's a more stable status. So in some cases it would be better to do the VAWA if definitely if they were married to a U.S. citizen, because they could apply for permanent residency right away. And then if it's a permanent resident, we'd have to look at the specifics of the case. How long is it going to take them through VAWA to become a permanent resident if they're married to a permanent resident? And how long, with the U visas, 3 years after approval is when they can apply. One thing I wanted to mention about these crimes is that because you might notice that if you have any experience with criminal law in Texas, these actually aren't the way that the penal code in Texas looks. Since it's a federal law, they basically created categories. And so, in Texas, you might have something charged as aggravated assault or assault family violence, and then that could fit into one of these categories. So when we're determining if somebody's eligible, we're not looking for that exact wording. We're looking for something that will fit into one of those categories. And the same is true with sexual assault and abusive sexual contact. They're not going to fit with with the Texas Penal Code in terms of language, but it's a matter of finding a category that works. So a principal applicant can be either a direct victim and an indirect victim. I think direct victim is pretty self-explanatory. It's the actual person that the crime was committed against. And then the other type of case is an indirect victim case. And this can be if the direct victim was killed, either manslaughter or murder, and that was the criminal activity that the U visa application is based on, then a family member can apply as the indirect victim. And then similarly, if the direct victim is either incapacitated or incompetent, then a family member can apply as the direct victim. Indirect victims can be any of these people here. And when doing an indirect victim case, and some people may, these are cases that we refer to pro bono, so you might have an indirect victim case. It's important to remember that that person, even though they're not the direct victim, is the person who needs to prove that they meet all the requirements, that they have been helpful in the investigation or prosecution, and that they have suffered substantial harm. And a really good example of this case is if the direct victim is a child victim of sexual assault. We will often apply for a parent as an indirect victim. And that's specifically in cases where the direct victim is a U.S. citizen and doesn't need any immigration benefit. And so you would show substantial harm to, for example, the mother. And then you would also show that, for example, the mother was helpful in the investigation. Does anybody have any questions about direct victim cases specifically?
What about the age? Do we need to worry about aging out of?
Yeah, so the age is determined by the age of the victim when the crime occurred. So for anyone who was under 21 when the crime occurred, an indirect victim could be their spouse, unmarried children under 21, parents. Wait a minute.
So if
No, that might. Hold on. Okay. No, sorry. So these three are for any victim. An indirect victim could be a spouse, an unmarried child under 21, and then these two, if the victim is under 21, it could be the parent or the siblings under 18.
And so we wouldn't have to worry about if the sibling is, like, say 17 at the time, or be really close to
turning 18.
Turning, 19. So
you would have to worry about that, and maybe I'll go into that in more detail when we talk about the derivatives. But it's different right now. Immigration's policy is different depending on who that person is. So generally, for siblings, their age is held at their age when the application is filed.
okay.
It's complicated, and we'll get more into that in when we talk about family members who can qualify. But generally, for an indirect victim case, most likely we would only have, or what we see more often is either parent or spouse. So I personally haven't done a indirect victim case with a sibling, but it's possible. This computer's a little slow. There we go. Okay, so the principal applicant must have suffered substantial physical or mental abuse as a result of the criminal activity. Mental abuse is defined as the impairment of emotional or psychological soundness. And these are the factors that are used to determine if the abuse was substantial. Nature of the injury, severity of the perpetrator's conduct, severity of the harm suffered, duration of infliction of harm, permanent or serious harm to appearance, health, physical, or mental soundness. And there isn't a single factor that's used to determine substantial harm. And there's no, none of those factors listed in the last slide are any type of requirement, but it's basically taken, you know, as a whole, if the adjudicators deem that the harm has been substantial. And when they do that, they take into consideration if there's been previous trauma that has been aggravated by the current crime, that would that lends support for the fact that for the argument that the victim has suffered substantial harm as a result of this crime. They also look at abuse in its totality. So, for example, we see this a lot with domestic violence, where a report was made and it's assault, family violence, not aggravated assault, and it looks like with that incident, that would not be enough to prove substantial harm to the victim. With U visa cases, you can show that through maybe even if there's only one police report for assault, you can show through other documents that I'll discuss more later that that there have actually been a series of incidents that, when taken together, can add up to proving substantial harm for the victim. So maybe it's been, 10 years of assault, or maybe, whatever it is. They do, especially with domestic violence, take into consideration that the nature of domestic violence and the fact that it's a pattern of one person exerting control over another, and so they'll look at various incidents and various types of, physical abuse as well as emotional and psychological and verbal abuse. And when deciding whether the applicant has suffered substantial abuse, immigration uses the any credible evidence standard, which is excellent for our clients who often don't maybe have a lot of traditional forms of documentation of the abuse. We try to get police reports and protective orders whenever we can, but immigration is required to take into anything that we submit that's deemed to be credible. So we often also submit witness affidavits. It could be counseling records, letters from counselors or social workers, and we can talk more about that when we discuss the process. But basically, if a lot of what we see people submit for U visa cases doesn't look like official evidence. It'll be like a piece of paper in poorly written Spanish, but that's okay, as long as it's translated. Okay, so another basic requirement for applicants is that they have been or are being or are likely to be helpful in the investigation or prosecution of the crime. It's not necessary that the perpetrator of the crime was identified or arrested. It's not necessary that there be a criminal prosecution. What is important is that the client has not failed to cooperate during whatever that process was, and has not refused requests from law enforcement. They also have an ongoing responsibility. So once they have their U status, it can be, I haven't ever seen this happen, but it can be revoked if they fail to cooperate. So during the entire time that they're in U status, they are required to cooperate. In most cases, once they once the U is approved, there's not much requirement for cooperation from law enforcement if the case is closed, or but they are required, and that's something that's taken into account when they apply for permanent residency. Also, they'll need to show that they haven't failed to cooperate at any point while they were in due status. For victims who are under age 16 when the crime occurs, or who are incapacitated or incompetent, a parent, guardian, or next friend can fulfill the requirement for helpfulness. And the way that, the main way that we should prove that an applicant was helpful is through a certification that we get from law enforcement. And this is a requirement. Every U-Visa case that's submitted must have a certification from law enforcement, and that's Form I-918 Supplement B. It can be signed by either the head of the certifying agency or someone who's been designated as a certifier. Who you request the certification from depends on the case. In general, Austin Police Department will certify for cases that have occurred within the last 2 to 3 years. Okay, that's their policy. And if the case did go to prosecution, they will refer to the last, to either the district attorney or the county attorney, the last point of contact. So they will not sign, in most cases, a certification when there has been a prosecution. For felony cases, certifications can be signed by the district attorney's office, and for misdemeanor cases, it can be signed by the county attorney's office, as well as for protective orders, the protective order division of the county attorney's office will sign certifications for people with 2-year protective orders. In general, it can be any law enforcement judge or attorney that has investigative authority. So district attorney, county attorney, judges can sign. I have never had a case where a judge signed. Department of Labor can also sign if it's a labor issue and they've conducted an investigation, and CPS can also sign certifications. So another requirement for eligibility is admissibility, and basically a U-Visa application is considered an application for admission to the U.S. even if the person is already here. Because in many cases somebody has come illegally, they haven't been actually admitted. So applicants must either not be subject to any inadmissibility grounds, or they must submit a waiver. And the packet, the kind of thicker packet that we copied for you all, is a copy of the statute where you can find the inadmissibility grounds. It's in the Immigration and Nationality Act, Section 212A. And I did put this here, not be subject to any inadmissibility grounds, but it rarely ever happens. Most of the time, I would say, maybe in 98% of cases, you will be needing to submit a waiver. If for some reason you found that your client is not subject to any inadmissibility grounds, that's something that should be reviewed very carefully with your mentor to be sure. And I-192 is the form that is the waiver for U-Visa applicants. Basically, the U-Visa is unique in that it has a very generous waiver. So a lot of both criminal and immigration violations, as well as other issues, that would, for many people, be a barrier to getting a legal status can be waived through the U-Visa. If you want to go into so for you applicants, all grounds of inadmissibility can be waived except for this ground, which is Nazi persecution, genocide, torture, extrajudicial killing. If we want to look through that packet real quick.
There's an extra one.
Is there an extra one?
I can go grab it from my office.
Okay. Can I borrow this for a second, Michelle? Okay, and so this is something that for a lot of people who haven't done immigration cases before can be very complicated and somewhat confusing. So we're going to try to clarify it a little bit, but basically this is something that in any case should be reviewed really carefully with your mentor. And the reason for that is because, like I said, there's a very generous waiver for U-Visa applicants, and they, in many cases, this is their, this might be their only opportunity to have certain things waived. That if they don't have them waived now, can really, really harm them in the future when they apply either for residency or for citizenship, especially. And so we really, this is I think an area of concern for us because we don't want clients to miss the opportunity to have these things waived, and we don't want them to be subject to problems in the future. So I'll go over some of the more common ones that people, generally our clients, are subject to, but it's really something that can that people do entire hour-long trainings on is inadmissibility. So I'm not going to do that, but we do have the statute here for you, and after I go through this, I'd be happy to answer questions, and it's something that I think you'll sort of learn as you do the process, and something that you can feel free and should rely heavily on your mentor for. So just before we do that, the standard is discretionary, and it has to be in the public or national interest. All U-Visa applications are adjudicated at the Vermont Service Center, and by people who are trained specifically on issues related to these types of cases. It seems like they're pretty generous with the waivers, and so in most cases it will be granted, but we'll go into later how to ensure that it is. Wait a minute. Oh, okay. It's like, sorry. It's okay. Is there not another one? No. I guess not. Okay, sorry. Okay, so the most common inadmissibility grounds that we see with our clients are related to previous immigration violations. And then also criminal issues. If you want to turn to page 12, section 212A6 is where is listed all of the grounds related to people who have come into the country illegally. So that's the one that we see most commonly, is that somebody has entered the country without inspection. Another one that we see often is further down the page, 212A6C, is when someone misrepresents to an immigration official in order to obtain an immigration benefit. And this can often happen with people, if people are using documents that are false or documents that belong to someone else, or if they have a tourist visa and they have lied about their intentions either when getting the visa or when crossing into the U.S. So that's a common one that we see a lot. Falsely claiming citizenship is if the client has at any time said that they are a U.S. citizen. And that's a very serious one, and one that for many forms of immigration relief, that would just automatically bar them from that form of relief. Fortunately, with the U visa, it can be waived, and so it's really important to discuss in detail with your client if they have ever either said that they were a U.S. citizen to an immigration official or to any other official, if they've ever signed an I-9 for authorization to work representing themselves as a U.S. citizen, if they've ever voted fraudulently.
And their applications for public benefits.
Or in their application for public benefits, right, if they've ever claimed to be a U.S. citizen. And it's very, very important that if that person has done that, that they that's listed on their I-192, because it can be waived at this stage, but it's something that later on, if it wasn't waived and it comes up later, it could lead them to be deported. And then another common one related to immigration violations is if somebody has previously been removed or deported and then come back in. And then another common one is if somebody has been here without permission for a certain period of time and then leaves, they trigger what's called a unlawful presence bar. And these are all listed in here, but those are just some to be aware of, as well as certain criminal convictions are subject to inadmissibility grounds. Another common one actually is for someone who isn't able to obtain a passport, and that's something that can be waived. And that's especially common where there are children involved in the case, because in order to get a passport, they'll need the authorization of both of their parents, and in many cases, because of a domestic violence situation, they're not able to get the authorization of one of the parents. What I always tell my clients is to try to get a passport, and especially adults should definitely have a passport. But if for some reason they aren't able to obtain one, it can be waived on the I-192. I think I deleted my other slide on inadmissibility. So, do people have questions about admissibility and inadmissibility?
I'm sorry, so you said if something is missing from this waiver and you don't claim it now, then they can be subject of deportation, and then there's nothing that you can do after that. Like
Right.
saying like they already have a U visa and then.
Yeah. So usually where it would come up is when someone applies for citizenship. And actually we haven't, because the U visa regulations didn't come out until 2007, we have a lot of people who are permanent residents and have gotten that through their U visa, but we don't have people yet who are applying for citizenship.
Okay.
But in general, the people who adjudicate citizenship cases are very, very strict, because they see it as the last opportunity to deny this person a benefit. So, once they're a citizen, there's nothing that immigration can do, but they scrutinize very carefully. So if they're in their interview, if it comes up that this person maybe was here and then illegally and then left the country and then came back in illegally, and that wasn't listed in their waiver, it wasn't waived when their U visa was approved, that would make them subject to the permanent bar.
Okay.
What are the various mechanisms, immigration is going to use to collate all that information? Like, how would they know that somebody misrepresented that they were a citizen, or minor crime issues or immigration violations?
Yeah.
How do they know
I think
that?
it's sort of two ways. One is if there are discrepancies in the paperwork that's filed in the applications. If somewhere it says someone came in on this date and somewhere else it says they came in on this other date, then that's obviously gonna cause a red flag for that adjudicator. So, and then the other one is is in an interview. If the client says something that is inconsistent with applications or information that's been submitted to immigration previously. So I think the best way to eliminate both of those issues is to make sure that your client is telling you the whole truth about everything that happened. You can say to them, look, this is an opportunity to have a lot of stuff waived that would make you ineligible in other types of cases. And it's really, really important that you tell me the truth.
Well, for instance, does immigration, when they're processing the application, go pull data from Health and Human Services about what people claimed on their public benefits applications? And
when they're adjudicating a U visa, no, they typically wouldn't. With citizenship cases, they could. I don't know if they do. Do you know if they do?
To my knowledge, I don't think that they have a regular practice of going, for example, and pulling the public benefits records. Although if a red flag was raised, they definitely they might, depending on the officer. And a lot of times, like Hannah said in the interview, if your client doesn't know that a piece of information will make them inadmissible, for example, they might not realize that when they checked the citizenship box on their I-9, that was going to be a big deal, and then they tell the officer that in their citizenship interview, and suddenly, like, that's a huge deal that they didn't have any idea about. So that's.
And I think another thing to keep in mind is that I often, when I'm doing an intake or when I'm doing the forms, I'll often ask my client the same question several different times in different ways and get a different answer. So, and I think, part of it has to do with people not understanding what I am trying to find out because of either language barriers or confusing immigration language, and people not knowing really what information is important, because these laws are, I think, to most people seem very arbitrary. Checking a box somewhere on an application saying you're a U.S. citizen could permanently bar you for, to any benefit or to most benefits. And I think also people are afraid that saying something is going to get them in trouble or going to make them not eligible. So the way I approach that is I really ask them the same question a lot of times in a lot of different ways until I'm confident that they have understood what I'm asking. And that way you know that what you're putting down in the application is what the client tells you after being poked and prodded many times, because if it's not, then they get to their citizenship interview and they're poked and prodded, and that's where it comes out. So I say, okay, so when, for example, when did you come to the United States? And they tell me a date. I say, okay, was that the first time you ever came to the United States? Yes, it was. Really, there weren't any other times. Oh, well, there was that one time when I was little and my mom brought me. Okay, so we've got one other. And then, so you came that first time. How long did you stay? Okay. And then you came the second time. And have you left? No, I haven't left. Okay, you've never left the United States since the second time that you came. No. And then the next time I ask them the question when we're doing the forms, they say, oh, well, I went to Mexico because my dad was sick. And I say, okay, I needed to know that. But like literally, this is, it takes a lot of asking. And Natalie's going to do some of that when she does the intake. But she can't do all of that. And it's also a matter of repeated, so I ask these questions when I am doing the intake, and I ask them when I'm filling out the forms with the clients. And then I ask them at each step. And then I review the whole application with the client and say, okay, so this is, you entered then, and then you left, okay? But basically, I often will be at that, maybe the last stage of reviewing the application, and I can say, okay, so this is the last time that you came to the U.S. And they say, oh no, I didn't know what you meant. I went to Mexico for 2 months on this date, and it'll come out then, kind of just in time. And I'm sure that there are many cases where it doesn't come out just in time, and I've missed it. But we have to, do everything possible to make sure that we're asking the question in a lot of different ways and reviewing it many times, so that when the client understands and when they're presenting the honest information, that's the same thing that they're going to present to an immigration official later on in their not in the U visa process, but later on in the process, that they'll answer the same way.
And it's also important to ask them, not even like illegally, also legally
Right.
here, because I have with one U visa that I'm working, he had a H-2A visa. So he was here and he left to Mexico, cross the border to get the visa, and then came back. But since he had the visa to enter, he said, no, that doesn't count because I had the visa. But
Right.
no, it counts because he actually. And then there is a problem with the waiver because, and my mentor, she got that because I didn't thought about it. When he went to Mexico to get the visa, he
Triggered. Triggered
and
an
he
unlawful
also
presence
probably
crime.
lied also for to get the visa.
Yeah.
Because they asked if he has been in the United States, and he said no, I didn't.
Right.
So
Yeah, and it's often, tourist visas can often be pretty confusing because someone has entered legally, so, they're not, that's eliminating the most common thing that we see is that someone has entered without inspection. But in many cases, they, when they were either getting the visa or when they were at the border or at the inspection point coming into the U.S., lied about their intentions, and that would be misrepresentation. So if they said, yeah, I'm just coming to visit, but they've already got a house here and a family here, that would be they've triggered an inadmissibility ground. And we have, we have sample forms, and I think what we'll try to do is when Natalie does the intake, she will highlight what she thinks the grounds of inadmissibility are that this client is subject to. And then she can also give you, the actual language from the statute. But it's really your job to make sure that you are reviewing all of that with your client to make sure there's nothing missing, and maybe the fifth time something will come out that there's an extra exit or entry or prior contact with immigration, something like that.
Hannah, I just wanted to interject too. I think it's important to understand where the clients are coming from, and that our clients, they are oftentimes not very educated, and also maybe even illiterate, and coming from a place of a lot of fear of immigration or a lot of fear of any sort of like official processes, and they've been living kind of in the shadows for many years. And so when Hannah was talking about like them changing their answers, I think it's important to know like that's the place that they're coming from, and also that it's not always just that they're trying to lie to you or
Right.
things like that. So I think it's important to have that sort of cultural competency when you're working with your client, and also language barriers and just not understanding the question or understanding
Right.
happens a lot. So
Right. Yeah, and I think also, people don't really know what information is important. So, and anybody who is not an immigration attorney or doesn't work closely with immigration probably doesn't know what question is important. So it's not, it doesn't have anything to do with stupidity or trying to deceive you. I'd say maybe in a couple cases people are withholding the truth, but in most cases it's a matter of not understanding the question or not understanding what information is important. And you know, in those cases where people are withholding the truth is because they're afraid that they've got this wonderful chance, maybe the only chance in their whole life, to get a work permit and immigration status, and they're afraid that if they tell you that one thing, they're going to blow it, which is why it's really important to tell people, look, this is a good opportunity to get all of that waived, but I need you to tell me everything, because if it's not waived now, it's going to be a problem in the future. And in most cases, I would say probably in every case we're going to refer to a pro bono, that waiver will be approved. You know, I've only maybe ever seen one waiver not approved for serious criminal issues, and so something like that we're not going to give to pro bono. So you can, you know, don't make any promises, but say, you know, it's likely that if we send in this waiver, we're completely honest about everything in your history that makes you ineligible, that it will be approved. So, okay. So applicants can also include certain family members. Okay, derivative family members can be for a principal applicant who's under 21, the spouse, child, parent, or unmarried sibling under 18. And for principal applicants 21 or older, they can include spouse and children. Yeah.
Is this also at the age when the crimes or offenses?
Good
are
question.
occurred? Okay.
No.
No.
This is where it gets kind of tricky. So basically, immigration has they have a policy right now which doesn't really make sense. It doesn't really come from the law, and it's we're working on trying to get it sorted out. But I would say in general, the age is considered the age when the application is filed. Okay, so that's definitely true of the principal applicant. So if the principal applicant's application is filed when they're 20, then they can include all of these people, even if it's not adjudicated until after they turn 21. Okay, so the principal applicant's age is effectively frozen when their application is submitted. Same holds true for siblings, actually. So if an application for a derivative sibling is submitted when the sibling is 17, they're considered as qualifying. The issue that really comes up when you have children, and the reason for that, and it's not really going to apply for children in this case, but it is going to apply for children in this case, is that immigration has sort of reinterpreted the law to say that people in this category can only hold U status while they're under the age of 21. So that obviously causes a lot of problems for various reasons. One is that applications tend to take a long time to be processed. So we have a lot of people who are kind of in limbo and whose applications are basically being held until there's further guidance on how this how they're going to work those cases. But in general, if there is an age out issue, it will be, first of all, we're trying to not refer those cases, and then if there is an age out issue, it will be flagged for you, and that's something that we can discuss more in detail. But those are the people that are kind of in a tough spot right now, are the derivative children who are nearing the age of 21. So For derivative applicants, the qualifying relationship must exist when Form I-918 is filed, and that's the principal's application. It must exist when the principal's application is adjudicated and when the derivative is admitted to the U.S. The reason that's separate is in some cases, if the derivative is not already in the country, they'll be, their use status will be approved and then they'll be admitted later. So for someone out of the country, having a U granted is not an admission. It's an admission for somebody who's already in the country. But so if that process happens later, the relationship still needs to exist. The applications for family members can be filed either at the same time as the principal applicant's application, or while the principal applicant's application is pending, or after it's been approved. So there's some flexibility there. What is important is that the relationship existed before the principal applicant's application is filed, and that's comes up mostly with spousal relationships. So, and it's especially complicated in Texas because of common law marriage, which is recognized in these immigration cases. If the marriage was valid, where the marriage took place, or if it's a state that recognizes common law marriage, then that's valid for immigration purposes as well. So if you, for example, have a client who, one thing that I should mention is that derivative applicants cannot have been the perpetrator of the crime. So anybody who was the perpetrator of the crime on which the U visa is based may not be included. I think that's pretty logical. Yeah. But so, for example, if you have a client who is applying for a U visa based on sexual assault, and she has a partner that she's been living with for 6 years, and they have kids together, and they call each other husband and wife, but maybe aren't really clear on, whether it's actually a common law marriage. That would be something to discuss before filing the application. Do you consider, discuss common law marriage with them? If they are common law married, then that spouse can be included as a derivative. Then they also, or they would have the option to get married officially, but that needs to happen before the I-918 is filed. Okay, so if the I-918 is filed, and then somebody says, I have my husband and we've got 2 kids together and we've been living together, but something about it doesn't make it, they're not common law married, which could go back to before that date. But if they're not married when the I-918 is filed, then that person won't be able to be included until the adjustment phase, which is 3 to 4 years later. So that's another good thing to clarify with people. And then derivatives are subject to the same inadmissibility grounds as the principal. Okay, so derivatives do not, in general, need to prove that they've been helpful in the case, and they, in general, don't need to prove that they've suffered substantially. Okay, so they're qualifying because of their relationship with the principal. They're not qualifying because they have been a victim of crime. In many cases, they have been a victim of crime, but they don't. It's irrelevant to their application. And so, in terms of evidence, we usually for children just submit a birth certificate showing that they're the child of the principal applicant. For spouses, we will submit a marriage certificate or proof of common law marriage.
And if there's no birth certificate,
There's no birth certificate. You mean like if the person can't get a birth certificate? Or if there's really no birth certificate. They can submit other proof that that's their child. For example, if there are school records listing them as a parent, if there are any type of like religious records, like baptismal records, or you can kind of get creative if you really need to. In I don't think I've ever done a case where we actually couldn't get the birth certificate. In many cases, people have to get a family member to get one and send it, get one from home country and send it. If they absolutely can't, then you can kind of try to do affidavits and compile things that prove that that's their child. Y'all have any other questions about derivative applicants? Okay. So, what time is it?
It's 2 minutes till 1.
Natalie, do you want to just do a little explanation on like navigating
Mhm.
this, and then I'll go back into the process stuff?
Sure.
Okay.
So, you all have so now we'll talk about the actual practical part of putting together a UBSA. And you all are familiar, most of you at least have been oriented on where our training resources are, and that's on texaslawyershelp.org. And when you're assigned a case, of course, you'll have to set up your login, your user login ID on this website, and then you have all access. And we just went through and updated some of the forms to make them better. So you'll go into the UVSA Pro Bono resources, and then we have a step-by-step case preparation instructions set out for you, which includes templates and instructions. Oh, so I'm not logged in still. For each folder there are, and then we'll have this PowerPoint up here too that you can refer back to. And so for each folder in the step-by-step instructions, there are subfolders that have the templates and instructions and things that you'll need to use in preparing the materials for that step. And then there are also instructions. So let's go to the first client appointment, reviewing the intake, signing contract, and starting client on document collection. So, and this is just an example, we won't go through them all, but in this folder, the instructions always come down under resources. You can open those up. And these are really designed for people who have never done a UVSA case before, and we want it to be really accessible to you all who maybe are doing UVSA for the first time. So first, employment instructions. So we have bullet points with instructions and then some important notes. There's a lot of sort of tricky details in immigration law, and we've tried to outline things that we think you should have in mind and keep a lookout for. So this is an important note on signing the representation contract. Okay, so then you've got follow-up tasks and materials needed. These materials needed are what will be found in the materials needed folder, okay? So these are our templates. One thing that I didn't print out for you here, but that I wanted to outline is the document collection. Let's see. Checklist for client documents needed. So this has been recently updated, thanks to Hannah, and it's the checklist that you can give. It's here in English and then here in Spanish. So you can go ahead and write the principal applicant here, and then these are the things that you'll need. So yeah, it's kind of harder. It's easier when it's on the form. So the identity document, the birth certificate, the passport, etc. And then these are, so this is a list that you can actually give to your
Should we go through this and we'll go over this?
Yeah, and you can also go through this, like I printed this
Okay.
one out
Yeah.
for them, so, and you can explain the difference
Okay.
maybe between, yeah, the two.
Okay, so the pink sheet that you have is,
I'll go grab you one.
okay,
don't worry. Yeah.
Is what we use in our files to keep track of the status of the case and what's been done so far. And this is what we use to give to the client. Okay, so one of the things that you'll do in your first appointment is sit down with a client and I'll go to the English one and this form and go over what documents they're going to need. So the area on the top are things that will be needed for each, in general, for each applicant. Okay, so and I can tell you which things are like really essential and which are not. Birth certificates are very essential. Passports are very essential, except that they can be waived, like I explained earlier, if they can't be obtained. But
Well,
yeah.
passports. Why is it essential? Do I need to go advise my client to go to the consulate and get a passport now?
Because it's essential because a U visa is an application for admission. So it's as if your client was applying to be admitted to the United States, therefore they need a passport.
I mean, like
They're,
when I previously did a
Yeah.
VAWA case, I had to get a passport because when we went to the interview, they would actually stamp the
Stamp it.
visa.
right.
But this is visa is a little
Right.
different. I
They-
wasn't sure whether I need to have them get a passport for this case.
You do, and what will be, you won't actually submit the passport, you'll submit a copy of the passport. So basically you have to show immigration that the applicant is in possession of a valid passport. And then if they're not, then that needs to be waived on the I-192, on the waiver. But it's because they're basically saying, please admit me to the United States. And the United States is saying, okay, show me your passport.
And it would be waived under which one, circumstances here
Let's see.
is the valid?
There's a specific
Passport.
one for, passport. Do you know which one it is?
Because I had the question like if they were here, why I need the passport, and
Right.
an attorney
Document.
told me that if they were already here, they don't need it. If they are like outside of the United States and they need to come in, so
Okay.
I didn't ask my clients to get a passport.
Okay. It's on page 14. It's 212A7B I1 near the top of the page. So,
Okay.
so the other thing that is important to note is that U visa is a non-immigrant status, meaning that it is not a permanent status. And so you can see that this section 212A7B applies to non-immigrants, okay, which is going to apply to U visa applicants. And then in general, any non-immigrant who is not in possession of a valid passport for a minimum of 6 months from the date of the expiration of the initial period, et cetera, et cetera. And then this is another one that we often include, is the one below it, is not in possession of a valid non-immigrant visa or border crossing identification card at the time of application for admission. And it seems, it does seem like it doesn't make sense that for people who are already in the U.S., they need a passport. The reason is because it's being treated like they are applying to be admitted to the U.S. And so they're subject to everything related to admissibility, and therefore they need a passport. Did that answer your question? Yeah.
Bottom line is, have them go get a passport.
Yes,
constantly.
unless there are difficulties because of, getting an authorization for a child, or in some cases, people don't have the documents that they're required. In some cases, if they're not Mexican and they have to, for example, go to Houston to get a passport, the cost is prohibitive. So there are, I tell people to try, but don't you know, tear your hair out about it. If you're in the U.S., you know, it can be waived. Did you?
That answered my question.
Okay, great. In general, identity documents, we will include anything like a consular ID card. If the person has any type of visa, like a tourist visa or something, we'll include a copy of that.
There's a list down on the pink sheet too of
Yeah.
additional identity documents, and you can keep track
Yeah.
down there too.
And these are not required, but you know, we like to include them when possible. Okay, but definitely birth certificate and passport are required. Good moral character letters are included in the waiver. So basically, because the waiver is discretionary, we're showing immigration why they should approve this person for the waiver.
So these go with the I-192.
Yeah. So this is divided not by form. Okay, sorry. Here, the pink sheet, it's divided by like application type in general, but the one for the client isn't. Sorry about that. That's confusing. But yeah, so the good moral character letters are part of the I-192, and in general, we just tell people to get, you know, 3 to 5 letters from friends, family members, community members, teachers, pastors, anybody who knows them and can write a letter about, you know, their good qualities and what a good person they are and what a, you know, what a wonderful
Not
contributor.
employers, right?
Employers are okay.
Okay.
Yeah. Oddly enough. Employers, yeah. This says marriage certificate, divorce decree, and that's going to be only in cases where someone's showing a relationship to a spouse. Okay, so in general, you won't need that information for most applicants. If you have, if you're including a derivative spouse, and if that person has ever been married previously, or if the principal, if either person has ever been married previously, they'll need to include divorce, proof of divorce, and then marriage certificate needs to be included to prove, so that's part of proving relationship. So for derivative children, it's the birth certificate that proves relationship, and for derivative spouse, is the marriage license.
I assume domestic violence under the statute is not limited to spouse.
Under the Texas statute?
Well,
Or-
under one of the crimes that supports the visa application. Domestic violence, does that need to be perpetrated by a spouse, in which case you would have to show the relationship connection?
No. It can be anybody.
You only need to show the
Yeah.
relationship connection for somebody who's being included as a family member, derivative family member. So you, maybe I'm not understanding the question exactly, but you don't need to prove,
Well, if the
show
crime's
relationship
domestic
between the
violence-
perpetrator.
You know, the question was, if the crime's domestic violence, do I need to establish that it was the husband that was
No.
doing it, in which case I need a
Right.
marriage certificate?
You don't.
Okay.
So unlike VAWA, right, it's okay if it was, I mean, it doesn't matter what the relationship was, husband, boyfriend. So, yeah, so this would really only need to be included for people who are gonna be a derivative spouse. This says list of addresses for the past 5 years, and that's something that can go directly on the I-192 form. I just like to have people come in with that list, because often they have, you know, have things written down at home, so just have them prepare that.
And there's a template here that we've prepared. You don't need to file the template. That's just in order for them to be able to think about it beforehand, so you don't spend 30 minutes in your appointment trying to have them remember where they've lived for the past 5 years. Where is this? Okay, here you go.
Okay, and then this says $585 money order or fee waiver. So any fee that's required as part of a U visa application can be waived, and we often, very often, do waive them for our clients. There are 2 fees associated with the application. The one is for the I-192, and that's this. Sorry, it's not very illegible, but $585 money order. So $585 is the fee that immigration charges for Form I-192. And then the other fee is a $380 money order, which is charged for the work permit application. And generally what I tell my clients is if you can pay the fee, you should. But if you can't, we can request a fee waiver, okay? And it's not something that affects the adjudication of the case, okay? When we submit the application, that's decided right away is whether the fee waiver will be approved. And it's completely separate from deciding the approval of the case. So often people are worried, oh, well, will it make my case go faster if I pay? No, it won't. Will it affect my case negatively if I don't pay? No, it won't.
There's also an $85 biometrics.
There is no longer an $85
Oh, there
biometrics.
isn't? Okay.
Oh,
They
yeah.
eliminated that.
Oh, okay.
So sorry if you've already done a case and your checklist includes that. It's been deleted and it's been eliminated, which is nice. It makes it a little easier. So we have sample fee waiver forms, and I usually do this in the appointment where I'm doing the forms, the applications. If somebody is going to be requesting a fee waiver, then I'll go through this. And if you want to just scroll down a little bit, enter all of the information regarding their expenses.
And this line is for their signature, and you can type it. We've had, I've seen some cases where they, anyway, maybe this is unclear, but it's to sign, yeah.
Yeah. The Vermont Service Center is also very generous with these fee waivers. So definitely don't hesitate to do it. And if, if it's going to be a hardship for your client to pay the fee, you can recommend that they do the fee waiver instead.
You actually submit that to the immigration. You don't submit because this is my first time working with a fee waiver, and I fill out a form, an actual form.
Oh, right. That's another option. So
uh-huh.
yeah, you can do either. So there's, this is what we have always done, and then pretty recently they came out with an official immigration form,
Okay.
I-912, that is a fee waiver request. So you can do that. Vermont Service Center will accept either. I personally do these because they're very easy.
Well, the other thing that I had a question with this was, do you have any cases that they actually deny it because your client actually has some assets?
I have never seen Vermont Service Center deny a fee waiver request. So a lot of the other service centers will be much more harsh and strict, I think, because they process all of the victim-related applications in Vermont Service Center. They're pretty generous. So I have never seen one be denied. If after doing this you look at that and you say, wow, that person's income is a lot more than their expenses, you could recommend that they try to pay the fee. But
All of the U-Visa clients in our office and for the pro bono program, the clients have to be at least at 187.5% of poverty. So they will probably.
I was just concerned, like my client, they own a house,
Yeah.
right.
and they have 2 cars. And it's not a lot. It's like maybe like $10,000 in assets, but still,
So-
that will take
Yeah.
into consideration.
What you could
I was
do
kind of like
is
afraid.
either, and I think actually from this one, assets might be, I might have deleted it because of that same issue. You can either write in the assets and then explain just down here that what it is. This is a house and 2 cars, and then not include it in the total, maybe. Or you can just leave out the assets altogether because, it doesn't paint an accurate picture of what the person's actual monthly income. Yeah.
To what extent do you need to provide supporting documentation in terms of a copies of leases, copies of utility bills, or is it sufficient just to kind of list this out and sign it?
This miraculously is sufficient, which is very nice because there's so, like, you know, you need documentation for everything else. This is one area, at least with the Vermont Service Center, you know, it's totally different with every other service center, I think, and with other types of applications. For U-Visa applications, just that form is what we submit.
Hannah, we have about 10 minutes left, and I
Okay.
want to be able to talk about the declaration
Right.
before. There's a lot of information that we could go through, and like I said, most of it is available here on Texas Lawyers Help, and you have your mentor, and you also always have access to me if you have follow-up questions about any of this information. But just to end, I want to be able to talk about the declaration too, if you want to
Yeah.
talk about that.
Okay, yeah, and this is something that I think is challenging for people is to figure out exactly how to do the client's declaration. And the client's declaration is one of the most important pieces of the case in terms of proving substantial harm, proving that the person has been a victim of a qualifying crime. And the process that we go through is that we ask the client to write out their declaration, and you do that right before referring the case. So ideally, they should come to the first appointment with their declaration written out. And then that can be translated by a volunteer. But that's really the starting point for the declaration. So with any other letters, like witness affidavits, things like that, they should be translated directly, submitted in the original and the translation. The client's own declaration is different. Okay, you don't need to submit the handwritten original of the client's declaration. So then what I do after I get a declaration back from a translator, I put it into this template, and this is kind of divided up: background information, substantial physical and mental abuse, reporting the abuse to the police, and assisting with the investigation. And I generally go chronologically, and that doesn't always work exactly because a lot of times a lot of the substantial abuse comes after the report, you know, things like depression and post-traumatic stress and things like that. But in general, I will, in this background information part, include information about how the client met the perpetrator, if this was somebody that they had a relationship with. For example, in a domestic violence case, I met so-and-so in this, you know, in this way, at this time, in this place. And talking about, continuing with that example, talking about how the relationship developed over time. And then going into substantial physical and mental abuse. And depending on the case, that could be many incidents that are discussed in that section, or it could be one, if it was, for example, someone who was a victim of felonious assault, a one-time assault. But basically, I see the clients, what they bring me, the written client's declaration as a starting point for, okay, here we need to add a detail about this, here we need to add a paragraph about, you know, what happened when you called the police. And so it's something that is really ends up being a document that's been reworked by you and the client together. So that usually, personally, I usually take 1 or 2 appointments to do that, most often 2. I know some people in our office usually just do 1 declaration appointment. But like a good substantial, you know, I'm slower than most, but I'll do a declaration appointment in maybe an hour and a half and 2 hours. And depending on what I get to start with, that could be it. That could be, you know, in 1.5 to 2 hours, we've put in all of the necessary information. And in some cases, that's not it at all, and we have, you know, an additional or even 2 appointments, depending on how detailed the declaration is that the client brought you. So what is a couple things that are important. It's important that the declaration be in your client's words, generally. If those words do not make sense, then you should tweak them. Because we want it to be readable by immigration. So we want the client's thoughts and experiences and feelings to come across. But if it's not readable because it doesn't make sense, then it's ineffective. So, feel free to make some grammatical changes, to change the structure around, to add in information where things are unclear. Another thing that's common is that for people will say, they'll use someone's name in the beginning of the declaration, and then they'll write 10 pages, and they'll only write he for the rest of the 10 pages. Well, so that's something that can be easily corrected and should be easily corrected for clarity. Just feel free to go back in and say, and if it's unclear, say, oh, so here were you talking about your husband or your son? And go and make those changes. And typical length, I would say, is between 8 and 15 pages, and that's just average. I have seen 5-page affidavits, and I have seen 40-page affidavits. For your own sake, you probably do not want to do a 40-page affidavit, but that was, my client wrote, I've had a couple like that where my clients came in and handed me like a novel. And that takes longer, but generally the range is smaller than that. It should be detailed and clear, and remember that this is the main thing that's being submitted in your client's voice to represent their story, and it needs to show that they have been a victim of crime and what that crime was, that they were helpful in the investigation or prosecution, and how that, what happened exactly, because you're going to submit other documents like maybe the police reports or the court records, but this is how you fill in the details, like, oh, how did, and then you showed up for this appointment and you were interviewed by the prosecutor. Things like that can help create a picture of helpfulness, and then substantial harm. Yeah.
Based on what I hear you saying, and also based upon some exemplars I've seen in the past, and the nature of some of the crimes that are perpetrated, what I understand is it's not a time to be reserved, that the amount of graphic and detail needs to be in there.
Yeah. Yeah, it really does. And this is, I think, one of the reasons why the process can be hard for clients, because in some cases they are either living through this right now, and this is something very immediate, in which case talking about it is obviously going to be really difficult. Or in some cases, if the crime happened maybe 1 or 2 years ago, they've spent the last 1 or 2 years trying to forget all of that, and you're asking them not only to remember it, but to write about it and to talk about it with someone that they barely know in a detailed way. So it's hard. It's really hard. And as much, sensitivity as you can approach it with, you're gonna, it's gonna be better for your client, and you're also gonna end up with a better declaration. But yeah, if you, as much, maybe a little more than your client feels comfortable telling, I would say as much as your client feels comfortable telling you, but it's actually more than that, because obviously you don't want to sit down and talk about how your stepdad raped you or anything.
And also, I want to throw in, if you have a domestic violence case, when I screen for the case, I usually ask them if they were also victims of sexual violence by their abuser, and that's something that you should also double check with, and it's uncomfortable and it's awful to have to ask somebody to sort of think about that, but because the standard is a totality of the harm, that's something that the adjudicator will take into consideration and should be in there, and that you should ask the client.
And often in that case, in cases of domestic violence, it often takes a direct question, because people will tell you about the physical violence, the psychological violence, the verbal violence, but they won't tell you about the sexual violence. So, you will need to ask that. And, I think in domestic violence situations that have been going on for a really long time, you do not need to detail everything that ever happened. What I generally tell my clients in that situation is let's start at the beginning of the relationship and when was the first, time that there was abuse, and start with that. And then a few, if there are incidents that the client remembers in specific because they were much more serious or scary, then I'll do that. So I won't do for a lot of people they can't remember all of the times. But I try to ask people to think of times that they can remember and include that information, and that can all go towards substantial physical and mental abuse. Another thing to keep in mind is that, as I said earlier, past trauma is considered when immigration decides whether this person has suffered substantial abuse. So that comes up a lot in cases of, for example, if there's someone who has been a victim of domestic violence and previously in their life they witnessed their mother being a victim of domestic violence. That would be past experiences that would help explain why that was traumatic for them. Or somebody who has been, they're applying for a U visa based on being a victim of sexual assault, and they were sexually assaulted previously in another country by someone else in a completely unrelated incident, but that is relevant. And so, if that information can be included, that helps to show substantial harm. In terms of this section reporting the abuse to the police, it often will feel like you are stretching out something that could be said in 2 sentences. But it is important to stretch it out. And also it's important to recognize that I think one thing that can be good about stretching it out is you think about the effort and commitment that it took your client to take those steps that might seem pretty simple. Okay, so I called the police. The police came. They interviewed me. They asked me what happened. I answered all their questions. They took pictures of my injuries. And then 2 days later, I went to the police station and I sat down with the investigator and I had an interview and I gave him all the information. And maybe that was the extent of their cooperation with the police, but that's okay. In most cases, it will be more than that. If somebody has applied for a 2-year protective order, that is, you can request a certification based on the 2-year protective order, in which case you should include in the declaration, I went on this date to apply for the protective order, I gave my declaration, and then I went back on this date to court and I was granted the order. And I think, that it really, for our clients, all of those things that might seem, to be easy or to be simple are really difficult and really complicated given, barriers in terms of language and education and understanding the legal system. And then in most cases, because of fear of, that's been instilled in them. Yeah.
On the VAWA statements that I've done in the past, usually you have a last little section where the victim presents a hardship of if they were sent back to Mexico and I have kids, I don't have any family in Mexico, can't support myself. Do we include a similar?
Yeah, we do that. So we basically, can you go back to the thing? There's, I think, those 3 questions. So after going through all of that stuff, I generally try to include a bit at the end about why it's important for them to stay in the U.S. And that can be that can include, for example, if I went to my home country, I wouldn't have protection of the police against this violence. So safety concerns, it could be accessing services like counseling that this person needs as a result of the crime. It could be, for most people it's mostly economic, but it is good to ask about those other things in terms of like, security, safety, and if you had to go back to your home country, would you be re-traumatized? Would you have access to the things that you need, the services that you need as a result of being a victim of crime? And then I like to kind of end on a slightly happier note of what their what people's plans are for the future, and it's, I think, just kind of on a personal level, it's a nice thing to ask when you've been sitting there discussing all of these horrible things that have happened to them, to like, okay, well, now here you are at this point and looking forward, what would you like to do? What are your plans? And that's kind of a nicer way to end the appointment in a slightly more optimistic and strengths-based approach. The first question, how has this crime affected your life? That speaks more to the substantial physical and mental abuse. But I generally do have that part at the end, and if it's sequential, like the person experienced domestic violence, they reported to the police, and then at the end I'll have a section on, well, how did this affect you emotionally? Were you depressed? Did you have trouble functioning in daily life? How did it affect you financially? If you're now the sole income provider for your family, financial struggles, all of that that stuff I include various ways, and that also kind of takes some prodding and some specific questions, because people might not necessarily be thinking about it in terms of like, oh, I couldn't sleep for a month, but if they haven't learned about depression and symptoms of depression, they might not think that that's valuable information. So, and that's something that's included also in the form that we give to clients about writing their declaration, is some questions about trying to get at specific ways that they've been affected by the crime. Yeah.
If, in this case, the principal has derivative minors, should they include how it's impacted their children?
Mm-hmm.
Because I don't know if you wanted them to speak on behalf of their child also.
Yeah, they could.
Okay.
Yeah, if it seems like something that's been, we often do that in cases where, for example, domestic violence cases where they've seen that their children are acting violently or are fighting a lot, or if that's a concern, that can definitely be included.
Well, Hannah, I'm gonna stop us here. We're out of time. So